record. Okay. All right. So I'm not going to make any judgments here. So question 2, a witness in a contract case testified on direct exam that 4 people attended a meeting. When asked to identify them, she gave the names of 3, but despite trying, was unable to remember the name of the 4th person. So that's a classic refreshing recollection fact pattern. You'll see, wasn't able to recall. Here it says unable to remember. That is the classic. That's the classic fact pattern. So I'm thinking, okay, refreshing recollection. The attorney who called her as a witness seeks to show her his handwritten notes of the part of his pretrial interview with her in which she provided all 4 names. So that the issue that I think that tripped people up here is that it could be like the thing that I thought of is like, well, those are the attorney's notes, which can be privileged, and like, what does that do? So, but it's okay. The attorney, like, they will often provide their own notes to show just a part of something, so to refresh recollection. So what is the trial court likely to consider the showing of the notes taken? And so this does look like a proper attempt to refresh a witness's recollection. So B jumps out. That's what I was looking for, and it's there, but we just want to eliminate the other ones also. So a proper attempt to introduce recorded recollection. That's not what the attorney is trying to do here. The attorney is not offering the notes. He's offering to show her his handwritten notes. So A is factually incorrect. It misstates the facts. C, an improper attempt to lead the witness. That's incorrect. There's no leading here. Because it's the witness. This is just it's classic refreshing recollection. It's his notes of his part of the interview, and the other side is going to be able to look at the notes too to see what the attorney showed her. So it's not improper leading the witness. D, an improper attempt to support the witness's credibility. This doesn't support the witness's credibility. I don't think. I mean, maybe, I guess it does, but this isn't. That's just not what's really happening here. This is just trying to refresh the witness's recollection so they can keep going and they can testify. So B is the correct answer here. So that's a good one where I think you can see, okay, well, so you want to look for that type of fact. So unable to remember the name, so unable to remember, those words trigger the issue of refreshing recollection. Okay, so question 3. So start with the call. Should the trial court rule the witness's offered testimony is admissible? All right, so we have witness testimony. So then I think, okay, well, what are all the issues that deal with testimonial evidence? So I'm thinking, relevance. I'm thinking hearsay. I'm thinking credibility issues. Essentially, those are kind of the big things. Privileges can come up. But let's look at the fact pattern. The plaintiff sued the defendant who had constructed the plaintiff's house for breach of warranty of habitability. So they're telling you a specific claim, so you want to pay attention to that a little bit, just because you always want to think, okay, how is this relevant? At trial and cross-examination of the plaintiff, the defendant's attorney asked whether the plaintiff had sued another contractor 30 years earlier. So as soon as I see 30 years earlier, I'm thinking that's a really long time ago. It's a really long time ago. I mean, granted, it's for, construction of a house. So, and this is another building of a house. So that doesn't happen that often, but still, like, this is so old that I just think it's probably not relevant, and it's just kind of ridiculous. So the question was not objected to, and the plaintiff answered that she had some water problems with the first house she had ever purchased, but no suit was filed. So there's an issue. So she's making a specific statement that she didn't file a suit, but they don't object to the question, and she answers it fine. So we just want to pay attention to that and see what happens. So the defendant then called as a witness the contractor of 30 years earlier to testify that the plaintiff had brought suit against him for defects in the earlier house, many of which were like those now claimed to be found in the home the defendant built, but that case was settled without trial. So here, when I see this, I'm like, okay, well, this is 30 years ago. Now you're calling in external evidence. So called as a witness, a contractor from 30 years earlier. So you're calling in another person. So that is classic, like, irrelevant evidence, improper. Because it's 30 years earlier. It's 30 years earlier, and it just seems a little bit ridiculous. So that's why I really highlighted that 30 years earlier. They're saying it twice, and oftentimes the bar examiners, when they repeat something, they're really trying to draw your attention to it. I mean, I do think that they're trying to trick you, but like, they're not trying to totally bury it. Like here, they're really pushing that out. And I think a lot of people, when it comes to relevance, you don't want to exclude on relevance. For a relevance reason, just because the threshold is so low. But when a piece of evidence is that old, it's got to really have some, like high relevance. And I just don't think this does, especially because calling the witness, calling as a witness the contractor from 30 years earlier to testify, like that is just like, that's a classic example of just going a bit too far. So I like this, I was like, okay, this is a relevance issue. And so I was looking for that, and something that states the rule for relevance is D, no, because its probative value is substantially outweighed by the danger that it would confuse the issues and waste time. And that's exactly it. So it's confusing the issues of, like whether or not she sued this contractor earlier isn't super relevant to whether the case here for breach of warranty of habitability, it does go to her credibility, but not so much because it's from 30 years earlier and you can have these issues. So it's confusing the issues, and it's also just a waste of time because you're calling another person to testify. That takes a fair amount of time. So D is what I was looking for. So let's exclude the other. So A, yes, is proper impeachment because the plaintiff will have an opportunity to explain or deny the witness's statement. But then again, it's not proper impeachment because it's calling collateral evidence. It's collateral or extrinsic evidence on a collateral issue. Although impeachment or credibility isn't necessarily collateral, but this particular one, because it's so old, is going to be difficult. So A is out. B, yes, because the plaintiff failed to object to the defendant's questions on cross relative to the prior suit. That's not why. So so even though like that's true, the plaintiff did fail to object to the questions, but here we're now calling in another witness. So you have to object to this new witness's testimony. So that's why. So B is out. C, no, because the best evidence of the former suit is the court record. Best evidence rule is almost never the correct answer. But it's like you don't need to introduce that. That's when the content of writing is at issue. That's not the case here. So C is out. It's just completely irrelevant. So D is the correct answer. So all right, question 4. It's just should the document be admitted? So I'm like, all right, this is a document. So I'm thinking of all the issues that go with that. I'm thinking of relevance, hearsay, best evidence rule, authentication, is it your recorded recollection, all refreshing recollection, etc. So all right, so let's look at the fact pattern. So in an action by the plaintiff against the defendant, one of the issues is whether the defendant is a licensed physical therapist. So, okay, so one of the issues is whether the defendant is a licensed physical therapist. And so you think, okay, well, if you're licensed, then there's going to be some sort of evidence of that, just like, when you're an attorney and you're licensed, you can do a search. And if, the lack of the existence of a fact, like that is a fact by itself too. All right. Normally, the names of all licensed physical therapists are registered with the Office of the State Department of Professional Registrations. There we go. The plaintiff wishes to introduce a certified document. So it's a certified document, which is good. That basically authenticates it. Signed by the chief registrar of the department, who cannot be located, so that person's unavailable, stating that an examination of the department's rules does not disclose the defendant's name. And that looks like a statement of absence of a public record, which is a hearsay exception. It's not one that's frequently tested on essays, but this is one that you will probably see a question of like this on the MBE. So you just need to know that evidence of absence of a public record is admissible. Generally, it's certified, and it's got to be signed by the person that in charge. So you just need to know the detail on that particular rule. So that looks like it falls squarely within that exception. So A looks good. B, let's look at that. So yes, it should be admitted because the chief registrar is unavailable. So it's a correct result, but it's the incorrect reason. It doesn't really matter that the chief registrar is unavailable. That doesn't matter at all. The document is certified. It's signed by the chief registrar, and that's really all you need. So B is incorrect. That's the incorrect reason. C, no, because the document is hearsay, not within an exception. That's incorrect. If you didn't know this particular rule, absence of a public record, and what you need to do to have it admitted, then you might have gotten thrown off by that. But generally speaking, it's sorry, I've got to mute everybody because I can hear some noises. Okay. So if you didn't know about this exception, then C might have been an attractive answer, but this is why it's really important to know all of the exceptions, because you will probably see one for pretty much all of them. All of the hearsay exceptions, well, not all of them, but you'll see the ones that aren't as frequently tested in the essays in particular, I'll say that. And D, no, because a document is not self-authenticating. Here, it's a certified document. The document doesn't have to be self-authenticated. It's certified and it's signed by the chief registrar, which I think that's I think all you need. So D is incorrect. So A is your correct answer here. so this is the exception to the public record rule. So it's not it's another hearsay exception. It's not an exception to the public record rule, but I think it's part of the public record that like it's either the public record or the absence of a public record. So just double checking the hearsay rules. I don't remember if it's a separate exception or if it's the same one, but it is a hearsay exception that the absence of a public record when one would exist if that person was in fact licensed or if that fact existed and it would be recorded, then you can submit a document showing that there is the absence of a record. So just double checking that particular rule. It's either that the public record exception or the one right after it. But yeah. All right, question 5. So should the trial court's here ruling be upheld? So let's look at the fact pattern. So that doesn't really tell us anything. So we have to see, okay, well, what is the trial court ruling? And generally speaking, if you want to figure out what subject you're in, if you can't figure it out from the call, then you can look directly above and it will tell you usually. So it's on appeal from a verdict for the plaintiff. The defendant challenges the admission of the witness's testimony. So that tells us that we're in evidence, which is helpful. So that you know that when you're reading the call or that when you're reading the fact pattern. So the plaintiff sued the defendant for injuries suffered when her car collided in an intersection with one driven by the defendant. At trial, the plaintiff testified that she had the right of way over the defendant to enter the intersection. So the plaintiff testified. The defendant did not cross-examine her. That's fine. The plaintiff then called a witness to testify that shortly after the collision, as she pulled the plaintiff from the car, the witness heard the plaintiff say, "I think I'm dying. Didn't the other driver see I had the right of way?" So here, what they're trying to trick you on is they say, "I think I'm dying," which sounds like a dying declaration, but I highlighted the plaintiff testified because the plaintiff's available. So you can't use a dying declaration because the plaintiff must be unavailable. But it could be an excited utterance. And that unavailability is immaterial for excited utterance. So it is an excited utterance because you see the shouting, "I think I'm dying." And the statement here is, "Didn't the driver say I had the right of way?" That is so for an excited utterance, it has to be a statement made under the stress of the excitement about the event that caused the stress. So here it is, because it's about the car accident and it's happening as she pulls the plaintiff from the car. So that tells you that it's that they're probably still under the stress of the excitement, and it's about the event that caused the stress. So this looks like it's the excited utterance exception happening here. But they will often do this. So often when they're testing you on excited utterance, they're going to test you on dying declaration together. I've seen them do this a few times, or I've seen a few questions that are similar to this. So make sure that you don't fall for the trap of, "Oh, this is dying declaration," because the person has to be unavailable, and here the plaintiff testified. So should the trial court's ruling, the witness testimony was admitted over defense counsel's objection. And it should have been admitted because it does fall into a hearsay exception. So it should be admitted. Which is what the court did. So should the court's ruling be upheld? The answer should be yes, and then you should have to pick the right reason. So yes, because the plaintiff's statement was made under belief of impending death, which is stating the rule for dying declaration, but we know that doesn't apply because plaintiff is available. Or B, yes, because the plaintiff's statement was an excited utterance. Yeah, and it was. So so you see the exclamation point. It's about the crash, and it happened while pulling from the car, so the person was still under the stress. So B is the correct answer. I can highlight it just to be so I'm being clear here. Okay. So let's look at C and D also quickly. So C, no, because the plaintiff's credibility had not been attacked. Doesn't have to be attacked here. The plaintiff is kind of bolstering her own testimony, but it's not too much. She's just showing that, just trying to show that the other person did in fact cause it. So it's not, it didn't have to be attacked here. And then D, no, because the plaintiff's belief that she had the right of way had already been established without contradiction. Just because it's been established and it hasn't been objected to doesn't mean the jury is going to buy it. So you will often have multiple pieces of evidence to prove the same point, to prove a fact, because you want to be persuasive. But that doesn't mean that, once you have one thing to prove it, that's all you're necessarily going to introduce. Because you've got to convince the jury or the fact finder. So D is incorrect. So B is the correct answer there. Any questions so far? Okay, cool. All right, let's look at number 6. So if at trial the plaintiff offers the journal as evidence of the sales volume, is this evidence admissible? So we have journal as evidence of sales volume. So it's not just like a journal. So it's not just general hearsay, which is what I'm thinking. But it's journal as evidence of the sales volume. So I'm like, okay, well, how do they get this journal? So is this evidence admissible? So in the plaintiff's antitrust suit against the defendant manufacturers of insulation, so it's an antitrust suit. So you have to know a little bit about what that is. It's basically a monopoly on something. The plaintiff's interrogatories asked for information concerning total sales of insulation by each of the defendants in a particular year. So in discovery. So the thing to know here, when you see discovery and you see someone produce something in response to discovery, that is that party speaking. So they're saying, here you go, this is what you want, and it's in response to what you're asking. So it's that is a response, and it's a statement from the responding party. So the defendants replied to the interrogatories by referring the plaintiff to an insulation manufacturer's journal for the information. So it's that particular journal. So it's hearsay, but it's a hearsay. It's an exception because it's a statement of a party opponent, and there's all the different ways it can be a statement of a party opponent. It can be an adoptive admission. It can be a statement by an employee, by someone that's allowed to act. So you guys really need to know, you need to know more deeply than just statement by a party opponent. You need to know, what are all the different ways it can be a statement, and you need to know all those little rules that go that are inherent, because that stuff will be tested. So you really need to break all of those apart. So I very strongly encourage you to really look at those rules and dig out your critical pass cards, make notes in that column for notes. But this is so if at trial the plaintiff offers a journal as evidence of the sales volume, is this evidence admissible? And yeah, it is, as an adoptive admission of the defendants. Because if you offer it in response to discovery for in your own answer, then you're adopting that statement. So that is an adoptive admission. B, yes, it's a business record. That's incorrect. It might be a business record, but this isn't the best answer because it's not. There's not actually enough information to identify this as a business record, and because it's the defendant manufacturer of insulation. The defendants replied by referring to the plaintiff to an insulation manufacturer's journal. So it's not, you don't know whose it is. So I don't think you can actually state that this is a business record of whoever is responding. Just because of it sounds like there are, numerous defendants. And then you also you need the keeper of the record for a business record, but by producing it. Yeah, so I don't think this meets. I think you're right. Somebody mentioned the keeper of the record has to be there for a business record too. You do need to have somebody testify about that, which we don't have. But by producing it in discovery, that's it's similar. But this doesn't look like it meets the components of a business record. And I do know that it does meet an adoptive admission, because the way that they test adoptive admission also is, generally speaking, it's by having a response to discovery. There's other ways it can be, adopted as well, but that is one. C, no is hearsay not within any exception. Again, that would be correct if you didn't have if you didn't have adoptive admission listed, and you didn't know, you just didn't know the rules if you just didn't know the existence of it. So watch out for that. And then D, no as lacking sufficient authentication. I think D is really the trick here. That is the answer option that I think people would pick if they, if you didn't know that this would be an adoptive admission, because it's a response to discovery. So you're signing it saying, you're signing it essentially saying that this is a response to this is my response to your question on that. So A is the correct answer. All right, let's look at number 7. Okay, so should the subpoena be upheld? Doesn't really give us a lot of information there. But we see it directly above it. It says the lawyer moved to quash the subpoena on the ground of attorney-client privilege. So I see here, so a lawyer sued a client for his fee based on an agreed hourly rate. So, so I know that there's also, an issue here. It's attorney-client privilege. They might assert that, but that, to an extent, goes away when you're suing for a fee. There's stuff related to the privilege goes away there. So there are some exceptions related to fees. So based on an agreed hourly rate. The client subpoenaed the lawyer's time records for the days on which he purported to have worked for the client to show that the lawyer had billed an impossible number of hours to the client and others on those days. The client subpoena provided that any information concerning the matters handled for other clients be deleted or masked. So that's good. So that's saying that, the client's saying, redact anything for other clients or other matters. So I only want to see so the client is asking for only the information related to the client. Which is what the client is entitled to get. Also, time records are are not within the attorney-client privilege. So there, you have to know that as well. So the lawyer moved to quash the subpoena on the ground of attorney-client privilege and can't do that in this instance. So should the subpoena be upheld? The answer is yes. And the reason is because information about hours billed is not within the attorney-client privilege. It's also like other stuff not within the attorney-client privilege, just like, you know, the name of a client. Although there's some stuff going on challenging that right now, but for the purposes of the bar exam, you just need to know that, generally speaking, the name of a client is not privileged. So the name of a client and then also information about hours billed, those are not within the privilege. B, yes, because a lawyer has no right to invoke his client's privilege without instructions from the client. That's incorrect. That's a misstatement of the law. The lawyer does have the right to invoke the client's privilege. The lawyer is actually like, you need to do that. So B is incorrect. C, no, because a lawyer is entitled to a right of privacy for the work product in his files. This is a work product. The bills are not work product. So C is incorrect. That misstates that misapplies the law. D, no, because no permission was obtained from the other clients to divulge information. The information is being redacted, so that misstates the facts. So A is our correct answer. All right. Let's look at question 8. So let's look at the call. So if a prosecutor lays a foundation properly identifying the tape, should the court admit it in evidence and permit it to be shown to the jury? Okay, so there's a foundation properly laid. It's regarding a tape, so there's some sort of a recording. And should the court admit it in evidence and permit it to be shown to the jury? So there's the question here is twofold. So we want to just, let's go to the facts. The defendant is tried on a charge of driving while intoxicated. All right. When the defendant was booked at the police station, a videotape was made that showed him unsteady, abusive, and speaking in a slurred manner. So you have a videotape that's made. It's not compelled because the defendant's doing it, on his own free will. You're in an area where the defendant doesn't have an expectation of privacy, so that's okay. There's no issues there. So on a charge of driving while intoxicated. So there's a properly laid foundation. So should the court admit it and permit it to be shown to the jury? So A, yes, because it's a statement by an opposing party. That it's not a statement by an opposing party, really. It's generally speaking, so a statement by an opposing party. He isn't actually saying anything. He's just acting in a certain way. So there's nothing. Yeah, it's not a statement at all. So B, yeah, so it's the right result. So yes, and it's really just because it's relevant. So it's not substantially outweighed by unfair prejudice. And it's not because, a lot of people, and this is something you have to sort of understand. A lot of people with relevance will say, well, like, yeah, like it's super prejudicial to the defendant. And so somebody asks, the conduct in this instance, it's not considered a statement here because this conduct, it's not communicating a message, at all. So like generally when you see, conduct, like I'll turn on my camera for a second. So generally conduct is like, the classic one is like if someone does this, right? And that means like, I'm going to kill you, right? So you can do this, or if you shake your head, like I'm saying no, or if I nod, I'm saying yes, like that is communicating. That's a statement. That's conduct that's considered a statement. But this one where, you're just walking around drunk and slurred. But yeah, so that's why, okay, I'm going to turn the camera off. Okay. Cool. Yeah, I said that, no expectation of privacy because you're in a police station. Okay, cool. So it's not a statement, so A is incorrect. B, its value is not substantially outweighed by unfair prejudice. And that's our correct answer, so it should be admitted. Every piece of evidence, for the most part, is going to be prejudicial in some way. Anything offered against a defendant, and you have to look for things that are really not relevant to the case at hand. Here it's a charge of it's a DUI. And evidence that the person is drunk after they've been booked is like absolutely evidence on point. So it's totally relevant. The value is not substantially outweighed. So B looks good. C, no, because the privilege against self-incrimination is applicable. There's nothing the defendant wasn't forced drunk. There's nothing that's being compelled here. So there's no Fifth Amendment violation. And D, no, because specific instances of conduct cannot be proved by extrinsic evidence. That's dealing with a different issue. That's impeachment. This is just actually showing this is just showing that the charges, or that he was actually in fact drunk. So D is incorrect. So B is the correct answer. All right, let's look at number 9. So should the record be admitted? So as soon as I see a record, it's I'm thinking of a business record, or else I'm thinking of a criminal record. Um, so, um, so the fact pattern here: cars driven by the plaintiff and the defendant collided, and the defendant was charged with driving while intoxicated. So we have another DUI question in connection with the accident. She pleaded guilty. So the defendant here is the she. She pleaded guilty, was merely fined, although under the statute the court could have sentenced her to 2 years in prison. So it's a felony. Thereafter, the plaintiff alleging the defendant's intoxication had caused the collision sued the defendant for damages. So you have a criminal case, then you have a subsequent civil case, and this is really common. And you can use the guilty plea as a conviction. A guilty plea is a conviction, even though she didn't have to go to prison for it. So you can use that. You can use that against them. So okay, and then that's exactly what's happening here. Should at trial the plaintiff offers a properly authenticated record of the defendant's conviction, should the record be admitted? And yeah, you can use it to prove that the person was in fact drunk. So B is the correct answer here. A, you can't use it as defendant's character. And B, well, okay, I shouldn't say B. A is incorrect. You cannot use it as proof of the defendant's character. When you're doing that, you're looking at a former act to show that they were acting in conformity therewith. But this is the same exact act here. So you wouldn't. This isn't character evidence. So A is incorrect. C, no, because a conviction was not the result of a trial. That doesn't matter. You still get a guilty plea. A conviction's a conviction's a conviction. Or D, no, because it is hearsay not within any exception, and we do have an exception that applies here for the record, and it's properly authenticated. So D is incorrect. So B is the correct answer. All right. In a contract action between plaintiff and the defendant, so should the objection be sustained? So here, if you look directly up, it's in your expert opinion, how much is the land worth? So this is dealing with, okay, so it's in your expert opinion. So it's dealing with an expert. So you need to know the rules about experts. So in a contract action between the plaintiff and the defendant brought in federal court on the basis of diversity jurisdiction. So they're using some civil procedure facts here to try to throw you off. So the major issue is the value of a parcel of land. The plaintiff's attorney calls a realtor to the stand and qualifies her as an expert on property valuation. So she's an expert. So she doesn't have to base her opinion on, specific visits to the property or anything like that. Then it says, since the realtor had not personally inspected the property, that's a red herring, doesn't matter. The plaintiff's attorney was prepared to ask the realtor a hypothetical question based on evidence adduced at trial. This is what experts do all the time. However, the trial had already dragged on longer than expected, and to save time, the plaintiff's attorney merely asked the realtor, in your expert opinion, how much is the land worth? And that's a fair question. The defendant's attorney objects. The defendant's attorney objects, but that's fine. And should the objection be sustained? And notice they don't tell you on what grounds. So then they're expecting you to come up with the grounds, or maybe you're going to try to talk yourself into a proper grounds for an objection. So, and the proper grounds for the grounds for the inspection is probably that, okay, well, you didn't get the whole basis. You're just asking a question, an opinion, which is okay. That's something that is okay. So let's look at the answer option. So A, yes, because an expert may not render an opinion on an ultimate issue. That's an old rule. You don't need to worry about that. B, yes, because an expert must disclose the basis for her opinion. That's incorrect. You don't need to. You can just ask a question. And then on cross, the opposing side can ask questions. So B is incorrect. C, no, because qualification as an expert creates a presumption of a proper basis. That's just not a rule. That's not a thing. So C is an incorrect. That's a misstatement of the law. So D, no, because the defense is entitled to immediate cross-examination of the realtor. That's correct. Yeah, A is an old rule. There is something with an ultimate issue with rendering in a criminal case, and I think it's regarding state of mind. So there is something there, but here an expert can render an opinion on an ultimate issue in this case. So there is I think just one narrow exception that applies. So yeah. All right. So C is incorrect because it's not a rule. So qualification as an expert creates a presumption. That's not a thing. Qualification as an expert does not create a presumption of a proper basis for an opinion at all. You can give an opinion and then but it doesn't make a presumption that it's a proper basis for the opinion. You can impeach the person and show that, okay, well, their basis was wrong. So that's just not, it's just incorrect to say that being qualified as an expert creates a presumption of a proper basis for the opinion. Does that make sense, Erica? Okay, um, so just because you're an expert doesn't mean that that alone means that you're creating a presumption that the jury should presume that you have a proper basis. Like you can be qualified as an expert and have a completely improper basis for your opinion. Like you can use like whack science or like, maybe it's accepted, maybe you meet everything to be qualified as an expert, but I can impeach it to show why your basis is incorrect. So it doesn't create a presumption. The only thing it does is say that, okay, you are an expert on this, but it doesn't create a presumption that the basis for the opinion that you're rendering is proper. It has it in the answer explanations that are posted also. Okay, all right, cool. That makes more sense. Yeah, it just kind of goes beyond like you might think that C makes sense, but like that's not an actual rule. Like it sort of sounds logical, but like it's a presumption that then is rebuttable, but it's not. It's not a rebuttable presumption. It's just like that saying that just goes too far. Okay, so there are two evidence fact patterns that are essays that are posted to the twin page. So I'm gonna give you 30 minutes, and I want you to do the first one. Evidence one of them is California, and one of them is federal. There is, or it should be posted. I'll make sure that it is. But I have a chart. Um, sorry, excuse me, that I created, and we went over it with a July bar. Made sure that everything is correct in there. But there is a chart posted to the twin page. If you don't see it, let me know. And I'll go back and double check as well. But there is a chart that has the California and federal rule distinctions. If you guys have, your bar providers probably have one of those too. Students, I just like to provide that. Okay, it is posted. Cool. I just like to provide mine. I think it's a little easier to read, but some people like it, some people don't. So take from that what you will. But it's there. All right, but do question one. And then we'll go over it, and then I'll have you do question two, and we'll go over it, and we'll kind of outline it like I've done with some of the other ones as well. So I'm going to pause my screen and mute myself, and then I will see you guys. So it's 7:08. Um, it's 7:08, and let's get back at 7:40. Okay. So I'm assuming you guys have done this. Um, I so obviously we start with the call of the question. You read the call of the question, then you make your list A. You just make your kind of issue checklist. So assuming all appropriate objections and motions were timely made, did the court properly one, allow the prosecution to call Whitney, discuss, and two, admit the testimony of Whitney, Ella, and Fred, answer according to California law. So we know this is a California subject, so I want to immediately think, okay, well, what are my California subjects? And I know what they are. Evidence is one of them, and this does look like an evidence question. So, one thing that I want to kind of point out is that when we are going through these questions, I'm obviously identifying the subject for you, but that's not going to happen on the bar. So one thing that you need to work on, and even when your bar examiners are, or not your bar examiners, but your bar prep companies, they're identifying the subject for you. But um, you also need to be able to identify which subject it is without you being told, obviously. And it's not always easy, and that's something that can really throw people off when they get into the exam. So one thing. I have a packet of crossovers. I will contact the bar prep team at TJ, and let them know that should be posted. Um, I have it though. I can email it. I just have to dig it out of my email somewhere. But I do have that. So one thing you want to ask yourself is, okay, at what point did you know that this was evidence? Did you know that it was evidence? When it says, assuming all appropriate objections and motions were timely made, did the court properly allow the prosecution to call Whitney? That sounds pretty evidence-like to me. And admit, as soon as you're hearing something about admitting something, so that's admitting evidence, that kind of screams evidence as well. So here we really do know it from the call, but you won't always. So that's something to really be on the lookout when you're doing, when you're doing your essays on your own. And even if the subject's identified, really, like, at what point are you confident that you know the subject? Without, had you not been told. Okay, so that all being said, so then I see that and I make my list A. So your list A might be different. This is what I do. But because I'm like, all right, I'm in evidence, then I'm in evidence, then I'm going to make my list of the things that are commonly tested. And yours will vary. For me, this is all I need. My list A here, I just have, because I know it's California evidence, I'm listing Prop 8. Then I say, relevance, hearsay, privileges, and I think of, okay, and then I think documents, testimonial. Those are two real big types of evidence. I might also just say, testimonial that includes form objections, but I often forget form objections. So I might list that as well. But I know with documents, all the different things I need to look for. I know with testimonial evidence, different issues I need to look for, with, experts, lay opinion, character, impeachment, and those kind of go hand in hand. Documents, I think, are more of, best evidence rule, authentication, self-authenticating documents, etc. So for me, that's enough. But you guys need to have your own lists of, what, if you run through it, does it kind of cover, run the gamut of what's tested? So you might have one that's a little bit more detailed. What you need to have, though, what you really need to be able to do, though, is list, make your checklist, and be able to just draw it really quickly. You don't want to take a lot of time. You want to just be able to list it and not think about what you're including. It should be the same every time. And you really want to automate that process of just seeing, okay, all right, I'm in this subject. These are all the things I need to look for. Those are all the things you need to look for. All right. So that being said, let's go through and talk about the fact pattern. So here it says Vicky was killed on a rainy night. So okay, so there's a death. So I'm thinking it's probably going to be criminal. So she's killed on a rainy night, and I'm wondering why they're telling me that it's a rainy night. I want to use every fact somewhere. So you need to find a home for every single fact. That's critically important. If you don't find a home for every fact, you're probably not passing the essay. So you need to ask yourself why that fact is there. The prosecution charged Dean, a business rival. Okay, so there's he's a motive to kill, with her murder. So it's prosecution. So now we know we're in a criminal case. It alleged that on the night in question, he hid in the bushes outside her home and shot her when she returned from work. Okay, so they're giving us some of the background. So we have Dean. Dean's a business rival of Vicky, and they think that he, this is premeditated intent to kill murder. So at Dean's trial in a California court, so they're telling us again, it's California. They're like trying to make sure that you don't forget that this is California evidence. So remember that, just like they said, in that MBE problem where it was, 30 years and 30 years. Here they're saying California court, answer according to California law. They're really trying to make sure you don't forget to answer this according to California law. So the prosecution calls Whitney. Whitney, I'm thinking, okay, and then it says Dean's wife. But as soon as I see a name with a W, I'm thinking it's a wife. So as soon as I see that, I think of spousal privileges. And remember that there's those two issues. So you have spousal immunity and confidential marital communication privilege. Those are two different things, and you need to know the differences. And I put those rules, or the main pieces of the rules, in my outline there for you, to testify. 1 week after the murder, Whitney had found out that Dean had been dating another woman and had moved out, stating the marriage was over. Okay, so then I'm like, all right, well, is the marriage really over? So, what applies here is spousal immunity, confidential marital communication. So there's that. Still angry, Whitney was willing to testify against Dean. Of course she is. So there's going to be an issue here. Usually when there's a marital issue, then they reconcile. So that's probably going to happen. After Whitney was called to the stand, the court took a recess. So she's called to the stand. And then, of course, during the recess, Dean and Whitney reconciled. So now she can choose not to testify because there's spousal immunity, and the witness spouse holds it. So she can refuse to testify, and that's fine. So Whitney decided not to testify against Dean. Surprise, surprise. The trial recommenced, and the prosecutor asked Whitney if she saw anything on Dean's shoes the night of the murder. So the question here is this a confidential marital communication privilege or something covered under the spousal immunity? Because this is just what she saw. So that's a little bit ambiguous, and you're going to need to deal with that. So when Whitney refused to answer, the court threatened to hold her in contempt. Reluctantly, Whitney testified that she saw mud on Dean's shoes. So there's going to be some issues there. So really what this is getting at is spousal immunity, confidential marital communication privilege. So they're saying allow the prosecution to call Whitney. So you have to know the rules there, which I do include here, and we'll go over that in a minute. The prosecution then called Ella, Dean's next door neighbor. Ella testified that on the night Vicky was killed, she was standing by an open window in her kitchen, which was about 20 feet from an open window in Dean's kitchen. So there's going to be some issues. Okay, well, she's standing in her house, he's in his house, right? There might be some authentication issues. Can she authenticate his voice? So there's, but it's his next door neighbor. And this also gets to, so it's also on a rainy night, so you're going to be able to hear things as well. So that's where I'm probably going to use that fact. And it's alleged that he hid in the bushes outside her home and shot her when she returned from work. So it looks like he was inside her house. So it is, but this is Dean's next door neighbor. So she was standing by an open window in her kitchen, which was about 20 feet from an open window in Dean's kitchen. She also testified that she saw Dean and Whitney, and she heard Dean tell Whitney, "I just killed the gal who stole my biggest account." So I'm still thinking, okay, well, this is a rainy night. Could she really have heard this? And then also, you're thinking, okay, well, this is a conversation between a husband and a wife. But there's, okay, but they have to have had an expectation of privacy. If you have an open window, you don't necessarily have that expectation of privacy. You would if it was closed and someone was, eavesdropping, but I don't think this is truly an eavesdropping case, but you would want to really talk about that here too. Dean and Whitney did not know that Ella overheard their conversation. Just not knowing doesn't mean, though, that they have the expectation of privacy. Maybe had they, I think the open window is a big problem here. So we're going to deal with that. Notice too, though, how these questions are, well, I'll talk about that in a second. Dean called a friend to testify. Fred testified that on the day after Vicky was killed, he was having lunch in a coffee shop when he saw Hit, a well-known gangster, conversing at the table with another gangster, Gus. Okay, so you have Fred. Fred overhears this other conversation. So there's, he's going to testify about that conversation. So that's going to be hearsay. And it's not double hearsay just because there's two people. It's not double hearsay because this is just Fred testifying about a conversation he heard outside of court. So Fred testified that he heard Gus ask Hit if he had taken care of the assignment concerning Vicky. So there's one statement, and then Hit had drawn his index finger across his own throat. So that is also hearsay. So Erica, that's that example. That one obviously comes up a few times. But that is a communicative statement. So that's going to be hearsay, and you're going to have to spend some time there establishing that is in fact a statement. Assuming all appropriate objections and motions were timely made, did the court properly allow the prosecution to call Whitney, admit the testimony of Whitney, Ella, and Fred? Okay, so now we want to go through and make our list of issues. So I'm going to give you guys a couple minutes, and I want you guys to these are all of the issues that I listed. Let me see. I can probably zoom out. I want you guys to be able to see. Can you guys read that if I do that? Can you zoom in on your screen and then scroll down? Okay, you can't see that. Okay, I'm gonna leave this. I'll do this, and then I'll move it down. Is that okay? All right, so I'll move it down in a few minutes, but I want you guys to like go through these issues and I want you to match the facts up because then I'm going to go through it and do it. And then I want you guys to do an assessment where you look at the facts that I select and versus the facts that you select. And then I want to make sure that you're using every fact because I think that is, no, you're doing all of it. So you're going to do all of it. You're going to start with the, um, can they call the wife, which is the spousal immunity, confidential marital communication? Yeah. And then you're going to go through this stuff and I'll move it down. But I want to go through this practice of having you guys use every fact because I want you to see, I know that, I left and I went to another school. The person I'm learning from or working for is the person, she is like the person, that does this stuff. Like, I think she's probably the most well-known person in the country that does this stuff. And so I'm learning stuff from her and I'm taking that and kind of sharing it with you guys too. One of the things she said is like a 65 uses every single fact. And I know that I said, a 65 will hit the issues, but a fact triggers an issue and you do need to use every fact. So I want you guys to practice doing that. So I'm going to give you guys like, yeah, contemporaneous. So somebody asked, is contemporaneous statement the same as present sense impression? Yeah, basically, but it's just the California way of saying it. So, and I'm going to talk about some California stuff too. And one thing about just the paragraphing of the problem. So I'll give you guys like 10 minutes, but I'll move it down in a little bit too. Can you guys see it all now? What you need? Okay, cool. I'm gonna mute it so you don't hear me chewing candy. All right, does anybody need more time? Okay. All right, cool. So I want you guys, like, I'm gonna turn your mics on. I want you guys to contribute. I will unmute those that I muted because I could just hear papers and stuff. Okay, cool. So feel free to chime in. You don't have to type your answers. Or I can actually paste this in a Google Doc. Maybe I'll do that for the next one. But let's talk about this. So actually, I'm going to do this. Okay, so allowing the prosecution to call W. So here, so a couple of things I want to point out here. So one, this is super fact intense. This one is super fact intense. But if you go through and you do this and you think through the entire problem before you start getting in and writing it, you will have enough time to answer this. Like literally, if you go in and you type the facts that you need so that you don't have to go back and look at the fact pattern, you are better off. It's scary to do that because you'll feel like everybody else is typing and they're writing stuff, but everybody else is starting to type and then they're pausing constantly. And that's the thing that you can't hear. But they're pausing constantly to think about the problems and then they're not really finishing. So know that. All right. So we want to think about this stuff. So the first question here is, if my computer would go. Okay, so spousal immunity. So allowing the prosecution to call W. So spousal immunity, a person married to a party may not be called as a witness. Oh, somebody has a question. Okay. Yeah. So, okay, so somebody commented that, so relooking at the facts after making the skeleton was helpful. So you have a hard time making yourself do that. But if you do that, like if you go through and you read it, and you're like, all right, these are the issues that I see, and you list them all out, and then you go back and you're going to match up the facts, which is what we're doing. This whole process, even on an essay like this, will take you 20 minutes. And then you literally, like, you're just typing, and you're just like, all right, you're literally just typing, and it's so much easier. Okay, so spousal immunity. So should we have allowed the prosecution to call W? So a person married to a party may not be called as a witness by an adverse party, so here, by the prosecution, to testify against a spouse. So that's your basic rule. And then a couple of other things. So it applies to events before and during the marriage. And it's only asserted during a valid marriage, and the witness spouse holds it. So here, W could decide to not speak or not, or to speak. So here, did the court properly allow the prosecution to call Whitney? So here, I think, W and D are married. W holds privilege. W found out Dean had been dating another woman, and had moved out, stating marriage was over. However, no divorce had been filed, so they're still married. But that could be considered a separation. No divorce. So they could call her. So W willing to testify against Dean, but then they reconciled. So here, so spousal immunity. So the thing to know here is a spousal immunity. It's just saying, like, you don't have to testify at all against your spouse. But then they reconciled. So now W can. It doesn't matter what questions. It's just the ability not to testify. But then they reconcile after W was called to the stand. And then W decides not to testify, and they essentially forced her to. So she refused to answer. The court threatened to hold her in contempt, but she does not have to testify. So what I'm going to say here, so you see the amount of facts that I'm using, and I want you guys to compare. Did you list all of these same facts? Did you include all of these or not? And if you didn't include them, why not? Because you want to use as many facts as you can. So W decides not to testify. So, but W still has right not to testify because still married. And I'm going to say that court did not properly allow the prosecution to call W. So this is my conclusion. I often will do this, like I'm going to do this in pen. So I will often have this in different colors because still married. Court threatened to hold W in contempt, which was improper. Because still married. So spousal immunity. So spousal immunity will, under the spousal immunity, it was improper for the prosecution to call Whitney because she holds the privilege. She has a right not to testify, and they are still married. So I'm going to use those facts. Some of them, I'm going to use the facts for a counterargument regarding essentially that they were separated. But they had reconciled, and it's at that point that she was actually being questioned. It doesn't matter that she had already gone on the stand. She can change her mind. That's okay. But I am. So I use asterisks to mark where I want to include a counter argument. So somebody asked, I'll get to that. So she already took the stand and agreed to testify. It doesn't matter. You can revoke it. You can change your mind. The spousal immunity applies and protects her. So just because she took the stand and agreed to testify, that's something you're going to raise in a counter argument. That I don't think that she didn't waive immunity at that point. I think you can make that argument, but I don't think it would win. Okay, so then confidential marital communication. So this protects all marital communications made during the marriage if made in confidence. So with respect to, so the big thing here is spousal immunity, because that is the right to refuse to testify. Um, so that really is our big issue. But here you might also talk about the confidential marital communication, because that would not protect this regarding this particular line of questioning. So the let me change my color just to keep it clear. So prosecution asks whether W saw anything on D's shoes the night of the murder. W refuses to testify. Court threatens and testified she saw mud on D's shoes. This is not a communication. This does not make calling W improper. Okay. Yeah. So and let me so somebody has a question about, once you agree to testify, it's waived. Let me just, I can double check on that, and I realize I have to double check on the contracts issue from the other day too, for those of you that were there for that. I actually recommend that you outline. So somebody asked if you should outline in ExamSoft or on paper. Everybody will tell you to outline on paper. I agree. I think a lot of people are, and the reason is because it then comes into short-term memory much more so than writing in an ExamSoft. Also, the danger with ExamSoft is you'll just start to work, and then you will not keep track of time. So I definitely recommend doing it on paper. I think it's good because you can do it in different colors, so then you keep track. You can also check stuff off as you go through. So I do really think that it's a good idea. Generally speaking, if I was doing this in front of the classroom, I would do this on a DocuCam and I'd be handwriting it. But just because I don't have a DocuCam at home, that's why I'm doing it this way. And also just the tech doesn't work that way. But I do recommend doing it on paper, and really spending the time to do it this way. I've seen, I watched someone do it on a really complicated, psycho property problem the other day, and they got through all of it and pretty quickly. The most difficult issue, which was dealing with there was 8 different transfers, and it was dealing with you had to know future interest and all this stuff, and she got through it quickly. She knows the law really well, which helped. So yeah. All right. But yeah, I recommend doing this on paper and having a few different color pens. Okay, so it was improper to allow the prosecution to call W because she's still married and she decided she didn't want to do it. So there might be a waiver issue there, but from my understanding, it wouldn't. But you guys should just double check that rule. Okay, then admit the testimony of Whitney. Okay, so Whitney. So then we're talking about the testimony of Whitney. So this is also where. Okay, so you want to think about relevance. What did she testify about? Then the only issue here really with her is this relevant evidence. So remember, logical relevance is anything that would make a fact of consequence more or less likely than it would be without the evidence. So here, this is a murder on a rainy night. And Whitney testified that she saw mud on Dee's shoes, which suggests he was outside in the rain and waiting in the bushes because that's where there would be dirt to get mud. So just because it's raining, but we don't necessarily get I don't know. I've walked in the rain a lot recently and my shoes don't get muddy because I'm not walking in dirt. I'm walking on streets and sidewalks. So the fact that they're muddy suggests then that he was in the bushes outside her home. So that's why that's important. Does that make sense? Okay, good. And did you guys, like, as we go along, are you noticing, are you using all the same facts? Or the same amount of facts that I'm using? Good. That's awesome. That's awesome. That's the big thing I'm looking for. It's like fact use. Fact use is so important. So that's fantastic. Okay. So legal relevance. So legal relevance is evidence is legally relevant when it's or it's really logically relevant. Evidence can be admitted if its probative value is substantially outweighed by dangers of undue prejudice or unfair prejudice, confusion of the issues, waste of time, etc. So here, this is, I think it's highly probative. Highly probative. So highly probative because it places it makes it more likely was waiting in the bushes. And there's nothing here to suggest that it's going to confuse the issues or waste of time, anything like that. So I think it's legally relevant. Okay. And then let's look at the testimony of Ella. So here, and remember too that when you're writing these, you know, on the real exam, you know, you're not going to spend time breaking down. You're not going to spend time breaking down relevance into logical and legal. Like once you break it down once, you don't have to break it down again. You do need to address it. That's a good question. I'll get to that in a second, Andrea. Now with relevance, you do still need to establish it, but you need to do it very quickly. So I'm going to list it out here, but know that when you actually write it, you're just going to have a heading for relevance. You're going to have, say, C rules above, and you're going to have a sentence for logical relevance analysis, sentence for legal, and a conclusion about relevance overall, and that's it. So Andrea asked whether anything. Yeah. Okay. Yeah. That's what I thought, Adam. So it says nothing goes towards prejudicial because it violated bringing her to testify. It doesn't. So that other rule about it violated her spousal privilege. That doesn't make it not relevant. So you're going to exclude it on that basis, but you're not going to exclude it on a relevance basis. They're just two different concepts. Okay, cool. And then Adams looked up the actually, so yeah, the rule is regarding the significant portion. So if somebody has started to testify, so if a spouse gets up there on this with the spousal privilege, she got up there, but then they called a recess, so she hadn't started to testify. So just because she was sworn in, that doesn't waive it. And we think this makes sense. But if you start to speak, substantially speak on an issue, and then you say, "Oh no, I'm not going to talk about that," then you run the risk of, okay, well, you're being very selective about what you want to talk about. You can't just pick and choose when you want the privilege to apply. So if you start to speak, you're done. But she hadn't here. So that's why she didn't waive her privilege, even though she had been up on the stand. But that would be a good counter argument to bring in. All right. So, all right, everybody got that? So, so admit testimony of Whitney. So admit the testimony of Whitney. I'm going to say, under relevance purposes, I am going to mention in my conclusion. So, admit on relevance, or, I'm going to say relevant, however, inadmissible because violation of spousal privilege as established above. So I put my conclusions in green. This looks super Christmassy. I'm just still in a holiday mood, I guess. But so I have my facts in red, and then I have my conclusions, and I put my conclusions in green so that I make sure that I have one. And then usually, like, when I have this written down that I'm going through and I'm highlighting, I'm like crossing out the stuff that I've talked about already to make sure that I've addressed it. So that way I make sure that I'm not missing anything. All right, so then let's talk about testimony of Ella. So one thing I want to point out here is the bar exam fact patterns are often like done really nicely for you. So as much as you can be nice writing a bar exam. But the first paragraph is just about this was like the facts of the case. And then you have all the facts regarding Whitney. And you see that it's a big paragraph, right? So there's a lot of information in there. So this gives you a hint that this is going to be a bigger issue. You're going to need to spend some time there. Then they call Ella. So then, so that's a different call is dealing with paragraph 3. And then you see Dean called a friend to testify, right? And Fred, friend goes, hand in hand. And then, so then call 2C is about Fred. So each paragraph kind of goes hand in hand with a different call. So they do kind of try to make that nice and easy for you. So that's something to look for and to think about is just those paragraph breaks. Okay, so let's talk about testimony of Ella. So Ella's testifying. So she's testifying that this guy, is it logically relevant? Does it tend to prove a fact of consequence? So here, this is a prosecution for murder. So prosecution for murder, and this is a statement that D blah 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 just killed the gal who stole my biggest account. And this is and here the prosecution alleges so prosecution is saying that Dean is a business rival. A business rival. I'm misspelling stuff, but it doesn't really matter. Vicky. You can just do V. So this kind of goes hand in hand with the prosecution's case in chief. So I'm going to use that fact there too. So prosecution alleges Dean is a business rival of V. So that goes there. And then Dean and Whitney did not know that Ella overheard the conversation. But this goes to prosecution for murder. So it tends to show a fact of consequence. So this does tend to show that tends to show D killed V. So yes, logically relevant. Okay, and then legal relevance, right? So legal relevance, then I am thinking, it's it's highly probative of D's guilt and of prosecution's theory. Nothing suggests. And this is also on the night. Statement on the night he was killed. Okay. Nothing's just unfair prejudice. So, and then I'm going to say, so yeah, so this is legally relevant. So I'm going to say this is, okay, cool. Okay, so then authentication. So one thing you have to hear, so unless, so you have to authenticate a voice. So here we need to show that Ella, you need to establish that she does have personal knowledge of his voice so that she can authenticate his voice. So Ella is Dee's next door neighbor. So probably familiar with his voice. So she's standing by an open window in her kitchen, 20 feet from open window in Dean's kitchen. And then she also saw Dean and Whitney, and she heard So she didn't just hear it, she saw D and Whitney and heard D say, gal who stole my... So there's that too. So she can probably authenticate it. So it looks like she's familiar. She can probably authenticate that this was his voice. So I don't think there's any authentication issue. Okay, so out of court. Remember that you guys have to go through the basics of like, is it out of court? Is it being offered for the truth? So out of court, this was statement. So it's, at home, offered for the truth. So they're offering it to show that D did in fact kill V. So yes, it's hearsay. Oops. So then it's inadmissible without an exception. So then, and remember with California, I think I forgot to talk about the Prop 8 thing. I'll talk about that in a minute. California, they're all exceptions. You don't have to worry about exemption, exception, whatever. It's just exceptions. So you could say that, so here I actually have a modeling. This is not one that I wrote, so I can't share this. But they always talk about in some of these competence and personal knowledge, you just really don't need to do that because it's usually presumed. So I don't go through that. So here, they say you can do state of mind. I wouldn't necessarily do state of mind. I think that it's one that you can do. So, because it's usually like a statement that you make that you are going to do something, and here it's already after it's happened. But you could do state of mind to show, a lot of times it's used for like insanity or anything like that. I think that really what you should probably do is statement of a party opponent or an admission. And here this is a D statement. D statement. It does. I don't think that it actually looks like an excited utterance here. These, like, statements made. So it could be heard. Oh, that's actually really creative. This one isn't so obvious. Like, you don't have the facts here to like really scream an excited utterance, but the fact that she could hear it 20 minutes away and it's about something that is a startling event, like, suggests that it could have been an excited utterance. So heard from 20 feet away, which suggests a loud and it's about a startling event. I think, you could say, murder would be a startling event, or killing someone. So this is a statement of party opponent, so D statement. So I think the fact that it's D statement and it's being offered by the prosecution. So I think you could get it in that way. And I think you can probably also you probably can make the excited utterance. Excited utterance. Then contemporaneous statement. So offer to explain, qualify, or make understandable conduct of the declarant, and made while the declarant is engaged in such conduct. So the language is a little bit different from, what was the exception that you said, Sarah? It's slightly different. Yeah, present sense impression. Yeah. Thank you. So this is the California version of it. So you have to show the two things. So offered to explain, qualify, or make understandable of the declarant, and while engaged in such conduct. So the second part's going to be problematic. So he is explaining what he did. Oh yeah, you're right. Okay, you're right. Good call. Yeah, because we're in California evidence, you don't call it excited utterance, you call it spontaneous statement. And then contemporaneous statement. Um, cool. Yeah, thank you for that. See, I forget too. And like, if you forgot that, it's not going to be a death knell. Like something like that is like they get it. The bar examiners know. People make mistakes like that. So I do think that this is off to explain, make understandable. So he is saying, look, I just killed that person, right? He is saying, I just killed the gal who stole my biggest account. Because that's not fishy looking, but and made while engaged in the conduct, but he didn't make it while engaged in the conduct. He said it afterwards. But he said it afterwards. So I actually don't think this is going to apply. But I think it's something you can bring up because it's, I think it's something you can bring up because it does state what he just did. So I say, not applicable. And then here, I think you do have to talk about also the marital. So I think you can get it in under the. I think you can get under statement of party opponent. I also think spontaneous statement. So here is where you have the confidential marital communication privilege issue, though. So let me grab the rule from here. So remember this. That was good job, Maureen. So this is this isn't going to work, but you do need to talk about it. So it is a marital communication because it's a convo between D and W, but not made in confidence because not made in confidence because they had the open window and talking loud enough to hear, talking loud enough for someone 20 feet away to hear. So there's 20 feet away to hear. So, there's a rule with respect to eavesdroppers. If someone is eavesdropping, but she's not. If someone is eavesdropping and there was an expectation of confidentiality, then it's still protected, even though somebody else heard it because they only heard it because they were eavesdropping. So if someone's like holding up a glass to the wall, to hear it, but let me get back to that. Somebody asked a question. Disagreeing with what is okay if it supports the facts. I think that you could disagree with me on a couple of the exceptions. Like maybe you can come up with a reason for why some of the exceptions might apply, but I don't think that. I mean, if you can make an argument that it still was made in confidence, but they're putting that open window in, they're generally speaking an open window in a conversation that can be heard. That kills the expectation of privacy. Whether the killing words are privileged. Okay. All right. Cool. You got it. So talking loud enough for someone else to hear. So eavesdropper, I don't think that. So Ella doesn't count as an eavesdropper in this instance because she wasn't like doing it. Ella isn't an eavesdropper because she just heard it from when she was in her own home. So and the window was open. And they didn't have any like blinds. Like you can have a window open but still have like shades drawn. He could see inside. So which means that there's really no privacy. So there's really not a lot of privacy there. Okay. So I think that the confidential matter communication privilege doesn't protect it. So this is going to probably come in. So I'm going to be like, because it's relevant, it's authenticated, it's hearsay, but you have a hearsay exception, and then there's no privilege that applies. So there's a lot of issues in there. All right, now let's talk about Fred. So first of all, we're going to talk about relevance. So logical, legal. So this, how if I could spell. So with the facts here, so logical relevance. Logical relevance. So this is providing, an alternate. So this is logically relevant because it tends to show that the hit tends to show hit killed Vicky, not D. Right, so that's relevant. So it tends to show that. So tends to show D not guilty. So that's good. So yes, it's logically relevant. And then legally relevant. So highly probative. That D is not guilty. Nothing to show unfair prejudice, etc. So I'm going to say that it is legally relevant. So then I'm going to say that it's relevant. Okay, so the reason I talk about character evidence here, so because they're giving some information about that. So Fred testified that on the day after Vicky was killed, he was having lunch with a coffee shop when he saw Hit, a well-known gangster. And that to me is problematic. Well-known gangster. That's problematic because it's showing, okay, well, if you're a well-known gangster, then you're acting in conformity with that, and that's improper. So that is so offering to show that he is a gangster and acted as a gangster with respect to Vicky. Yeah. Okay, so I'm going to say that this is improper character. So I don't like this statement. Yeah. All right. So then, okay. So I'm going to say that that part of it's probably not going to be okay. But let's look at the rest of it. So he saw Hit talking with a well-known gangster convention at a table with another gangster. So I think with both of those, it's going to be problematic. Yeah, the gangster part's not okay. So I think well-known gangster and then conversing with another gangster. Like you don't need that. Like that's just improperly characterizing them. So let's see. So somebody asked, okay, isn't this in reference to Fred's character as a witness, not Hit? I might be confused. So I don't think so. This is what this is doing is it's characterizing Hit and Gus as gangsters. So what that is doing is it's basically going to by doing that, you're saying that these two guys are well-known gangsters, and so because they're well-known gangsters, we're going to assume that they were acting as gangsters again, and that is character evidence. It has nothing to do with Fred. It's Fred. It's talking about Fred's testimony, and Fred is talking about the character of these other two, and you can't do that. Okay, cool. So then let's talk about Gus's statement. So it's hearsay, so it's out of court, right? This is easy. You still have to do it though, so it's out of court because it was in a coffee shop, and you're offering it for the truth. Offering to show that that Gus really saying that Hit had taken care of the assignment concerning Vicky. So i.e. he had killed Vicky. So yes, it's hearsay. Okay, and then exceptions effect on the listener. Let me see why they said that. Hold on 1 second. Let me make sure I've got the competence, personal knowledge. Oh yeah, so it's not offered for the truth, but to give context on its response and show. So really, what you're doing is, so you can say that it was offered and it was hearsay, but you can also say that it was not. That it was offered for a non-hearsay purpose, i.e., the effect on the listener. So getting the response, getting a response from Hit. Hit Ray whether Hit had carried out the murder. So I think, yeah, under that basis, you're gonna, so I'm gonna say, yeah, it's non-hearsay effect on listener. So I think that comes in. Then we have Hit's response. So hearsay, so yeah, it's out of court because it is at the coffee shop. Offered, okay, so here you do have to talk about whether it's a statement because he's, so statement equals contact that communicates a message. Okay. And drew his index finger across his own throat means he had killed her. So offered for the truth, that i.e. that he killed, yeah. Oops. That Hit had killed, had taken care of the assignment concerning Vicky. Yeah. All right. And then here, there's a couple of things you can do. So you can say, we don't know. So Hit. So one thing you have to remember is somebody is not available to testify if they're asserting their Fifth Amendment right to remain silent. So there's a statement against interest, which does require unavailability, and this would be a statement against interest because it's a statement against the penal interest of both Gus and Hit. So this is statement against penal interest of G and H because shows H killed someone and G might have been a conspirator, I think, because they're talking about it. Okay, yeah. And then adoptive admission. So silence by a party. Yeah, you can, adoptive admission. So this is him saying yes. So, sliding his index finger across his throat, Drew's index finger across his throat. I think all you really need is statement against interest. So this is an admission here. Admission that he killed V. So that's it. So then I think that this is going to come in. Okay, so you see here, there's a ton of issues. This is a classic evidence fact pattern. There's a ton of issues built in. You see, there's so many different things you have to go through. But even doing all of this, for me to sit here and type out all of it, it didn't take that long. It really didn't take that long. And I think especially, I'm going through and I'm explaining it, so I'm pausing. But if I hadn't done that, I probably would have gone twice as fast. So it's really good for you to go in and fill all this stuff out. Because then, I still going through this whole process really probably would have taken me 20 minutes. And if I have 40 minutes left, I can go through and I can hit all these issues. I can go through and hit these issues, and I'm confident. And I've thought about everything, and I know that I've hit all these issues, and I've used every fact. So that's the goal. Any questions about that? Oh yeah, so let me talk about Prop 8. So Prop 8. So this is a California case. So you're going to talk about Prop 8, that this is a criminal case, so that it applies. So then everything is admissible except when it's not. So you just need to really make sure that you know. But generally speaking, the stuff is just going to come in. Generally speaking, Prop 8 doesn't really make a difference. So it really does have, in effect, it has the same limitations, or you have the same limitations, but you do need to just kind of raise it. You need to raise it and talk about it at the beginning. So yeah. So just raise it, talk about how it applies, so it allows more things in. But generally speaking, it's just not going to make a difference. So just know that. Know that it's just something you need to address at the front, and then go through and do everything else. And then you should be fine just doing that. All right, so it's 8:50, shockingly. So I don't think we have enough time to go through a second evidence essay. Yeah, mention it. So just mention Prop 8, talk about it, talk about how it applies, and then move on. And even if you get, with respect to Prop 8, even if you get a civil case, and it's in California, Prop 8 doesn't apply to civil cases, but you still need to say, there's this thing in California called Prop 8. I mean, don't say that. Don't write colloquially. But you need to mention it, say that it doesn't apply, and then keep going. But you do, because it's California evidence, that's something that is expected at the beginning of an essay. So we don't have time to go through a second essay, but I'm happy to post a checklist for that one. And then if you guys have any questions, you can let me know. But do you guys have any questions about the one we just did? Okay, cool. All right. So I'm going to go ahead and call that. If you have any questions, Erica, I will get back to you about our emails earlier too. So I just have to look at that stuff, and I should have some time tomorrow or tonight. All right, cool. All right, everybody else, have a good night, and I will see you on Sunday, hopefully. Bye. Yeah, of course. Good night.